speak briefly on the subject of arbitration appeals in international cases. This is a topic which is controversial, to say the least, and occasionally it becomes very emotional. There are those who take the view that an appeal in an international arbitration case is anathema to the institution of arbitration, while others take the view that having the safety net of an appeal process will serve to reinforce the intellectual rigor which we would like to see arbitrators bring to the table. Jennifer Kirby, who was formerly with the ICC, wrote an article recently called "What is an Award Anyway?" published in the Journal of International Arbitration. She made comments on checks on arbitral power and wrote, "The power an arbitrator wields when rendering an award is exceptional. We are all familiar with the classical image of justice with the scales in her left hand and a sword in her right. Well, in international arbitration, that sword is more like an M16. In making his award, an arbitrator is generally issuing a decision that, one, cannot be reviewed on the merits, and two, is enforceable around the world. No state judge anywhere has anything like that kind of power, and arbitrators wield this power with very little accountability. It is often not clear what, if any, ethical rules apply to them. They are usually either partially or wholly immune from suit. Their decisions in commercial arbitration are rarely publicly available, and there is no Zagat guide to tell you which international arbitrators are good, which are bad, and which are just plain ugly." Now this concern, it may lie at the root of, or give rise to the comment that we heard last night from Lord Goldsmith, that arbitrators carry sometimes toxic baggage, and I believe that he was referring to the lack of accountability of arbitrators. Michael O'Reilly, in another article on this subject in the journal Arbitration, suggested 5 purposes for an appeal structure in international cases. He lists these purposes as 1, error correction, 2, jurisprudential development, 3, regulation of procedural extravagance at first instance, 4, intellectual and moral discipline, and 5, avoidance of informal blocks on recognition and enforcement. In respect of procedural extravagance, he suggests that the lack of an avenue of an appeal can lead to extravagant submissions on every conceivable point, with the effect that the arbitration process, rather than simplifying things, makes the proceeding more complex and leads to an escalation of costs. He argues that the existence of an appeal procedure will immediately pay for itself. I'll just digress for a moment to say that in my own experience, having had the opportunity earlier on in my career to observe English barristers and the English commercial court system, I was very impressed with the ability of the barristers to narrow the issues to what were truly critical issues, against the wishes sometimes of the solicitor, against the wishes of the client to shotgun plead every issue. And the reason for that was that the barrister knew what the commercial court judge was going to do. There was predictability, there was certainty in that system. And in the arbitration system, I think that we can benefit from that same approach, which is to bring what I'll call intellectual rigor to the process by potentially having a greater access to an appeal procedure in international cases. In a recent survey conducted by today's General Counsel, respondents were asked to select 3 reasons why they might choose not to arbitrate. 66% said one reason was the difficulty of appealing the decision. Another 43% said that a major problem for them was that in the arbitration process, the arbitrators were not required to follow legal rules. Now, for international commercial arbitrations conducted in jurisdictions that have adopted the Austrian model law, there is no right of appeal on a question of law. For domestic cases, it is common to have a statutory right of appeal on a question of law, usually after obtaining leave from the court, and leave is not generally available unless the issue would lead to, involved would lead to a miscarriage of justice. Jennifer Kirby, again, argues that an award that is just plain wrong gives rise to a substantial injustice that not only is made worse by the fact that an award cannot be set aside, but also that arguably threatens to undermine the very broad powers and reputation that arbitration has. She gives an example in her article of a potential injustice involving an ICC award. The contract contained a provision limiting consequential damages to $1 million. Even though the tribunal quoted this provision in their award, they proceeded to award millions of dollars in consequential damages. That was far in excess, obviously, of the cap. In that case, the error was caught by the ICC court's scrutiny process, and when the error was brought to the attention of the tribunal by the ICC court, they revised the award down, but if it were not for that scrutiny process, the award most likely would have been immune from any kind of review in the international arena. Now, not every institution has a mechanism for a substantive scrutiny of arbitral awards. There's a recent trend now to provide such mechanisms. The American Arbitration Association and the ICDR, the international arm of the AAA, recently published new appellate guidelines that allow parties the option to agree to have an appeal available from an arbitration award that is within the arbitration process itself. The grounds for appeal are that the award contains either an error of law that is material or prejudicial, or determinations of fact that are clearly erroneous. The appeal would go to, it is fast-tracked, it has to be dealt with within 3 months. It would go to a panel consisting of former federal and state judges and arbitrators with strong appellate backgrounds. Now, I'm not suggesting that the BVI Center should have that kind of a panel, but it's something that could be discussed. The CPR also has recently published arbitration appeal procedures, likewise in the same manner as the AAA has done, which provides an internal appeal procedure. Now, moving on, the question of what is an error of law sufficient to ground an arbitration appeal is also controversial. The Supreme Court of the United States, in a recent decision in Hall Street Associates and Mattel, held that the grounds for vacating an arbitration award under the Federal Arbitration Act addresses only egregious departures from what the parties agreed for their arbitration, including corruption, fraud, evident partiality, and misconduct. The Supreme Court reasoned that there was no basis to conclude that state statutes that did permit a form of appeal contemplated anything but an appeal for arbitral errors that were examples of extreme arbitral conduct, and that accordingly there is very limited appeal available under the FAA, whether it's an international case or not. It's been argued, and we heard this morning about that an appeal in the United States is available for manifest disregard of the law, but it is not clear that such a ground really is available. Questions arise as to whether an arbitrator who is bound by the arbitration clause to comport with a particular specified choice of law, whether it be such as the state of New York or the law of England, and commit reversible error by not applying that law correctly, is subject to any kind of an appeal. The controversy again shows up in a decision of the Supreme Court of Texas, which held that where the parties so limit the power of or jurisdiction of an arbitral tribunal, that an appeal is available. Anglo-Canadian concepts of judicial review contemplate review for what can be described as jurisdictional errors. It is questionable whether that kind of error that arises in international arbitrations could be construed as going straight to jurisdiction and perhaps give rise to a form of appeal. I'm going to just jump ahead to talk about the BBI statute, which incorporates Article 34 of the model law, which really only allows review for those most egregious errors that include denial of due process, the tribunal is improperly appointed, or the question that is submitted was outside the scope of the arbitration agreement. There would not, under that adoption of Article 34 of the model law, give rise to an appeal for a failure to follow the law that the parties choose. So I'll just give you one, what I'll describe as a conundrum, and leave you with that because I think it raises the question of whether we can better word our arbitration agreements to protect against an aberrant arbitration award by limiting the jurisdiction or the powers of the arbitral tribunal. And for this discussion purpose, I'll refer to that clause that is contained in the Article 28 of the Model Law, Article 62 of the BBI Arbitration Act, and in most international commercial arbitration statutes, which says that an arbitral tribunal can only decide ex aequo e bono or as amiable compositeur if the parties expressly agree that that may be done. My question is, what if, for some reason, the arbitral tribunal doesn't follow that mandate? It's an international case, and they decide that they will decide it according to fairness or equity or somehow cutting the corners of the law, which is what this concept of ex aequo e bono or amiable compositeur is meant to embrace. It does not appear, and I think the short answer to my question, and it is probably unlikely that a court would set aside an award that is contains such a breach of a mandatory provision of the governing statute in the lex arbitri, but that my question is that if the parties specified in their arbitration agreement that the arbitral tribunal must decide in accordance with the applicable law, that the failure to decide in accordance with the applicable law is an excess of power on the part of the tribunal and an error of jurisdiction, whether or not that might provide some protection against what might be a truly aberrant award. The answer to that question, I believe, is one that cannot be predicted, and until a national court or someone such as Mr. Justice Leon decides it, remains a question for further discussion. And to conclude, I would say that I think we should be more creative, at least considering the option of an appeal process, whether through a national court or through an institutional mechanism, when we are advising clients in wording arbitration clauses, and that there can be no harm, in my respectful submission, to adding words that say arbitrators who don't do what they're supposed to do, that is, if they don't follow the law that they've been told to follow, that would constitute an excess of power. Thank you.